Welcome to Books and Five, where we are interviewing the authors of recently published books on relevant topics. I'm very excited about the guest that I have here with me because she has written an excellent new book about a topic that is concerning, that is very in the news, and it's something that I want to learn more about. Rachel, can you introduce yourself and tell us where you are joining us from today?
Yeah, no, thanks very much. My name is Rachel Barkow. I am a law professor at New York University School of Law.
Great. And I'm assuming you're joining us from New York?
Yes, I'm in New York right now.
Great. Let's jump right into our first question. It can be difficult for people from the rest of the world to truly understand just how many people are incarcerated in the United States. Let's begin by diving deeper into the demographic numbers of just how many Americans are in prison.
Okay, sure. So in America, we hover around the 2 million mark for the number of people incarcerated. Sometimes it's a little bit more, sometimes it's a little bit less. And it's roughly a quarter of the world's incarcerated population. So the United States has about 5% of the world's population, but we have more than 20% of the people who are incarcerated in America. And it's actually, it's closer to 25%. So it's a very large ratio of people that we incarcerate in America. They're largely poor people. And it's disproportionately people of color, mostly men, but the number of women who've been incarcerated has also increased in recent decades, and they're there for a variety of crimes. I would say. Roughly, most statistics that I see place it at about half are there for some kind of crime involving violence, or at least it's characterized as violence. So, that can range from something really serious like a homicide, but it could also be a form of assault, a slap, a fight that's not that extreme, but would still be characterized as violent. And then, so that means about half are there for some kind of non-violent offense. A lot of people think it's drugs that is the huge engine of mass incarceration in America. But as it turns out, drug offenses are really only about a quarter of our incarceration population in America.
Got it. So, can you tell us a little bit more about is it all throughout the country or are there specific geographic areas?
It's the incarceration rates are pretty high all across America. So the states do vary, though. So we have some states in the Northeast of America. Massachusetts would have a lower incarceration rate than a state like Oklahoma or Louisiana. They have much higher rates, but even a state like Massachusetts, which would be relatively low for America, is still going to be a much higher incarceration rate than it would be anywhere else in the world. So it's pretty uniform that states across the United States have these high rates. In terms of the age of the population, most people who commit crimes tend to be young. The kind of peak crime years for people tend to be up until about the age of 30. But because our sentences are so long, we have a lot of people who are incarcerated who are older because, they may have committed their crime in their 20s. But if they're getting a 20, 30, 40-year sentence, they find themselves still in prison when they're quite old. We have a lot of people who serve life sentences. So we have a significant elderly population that's incarcerated as well. But, most people, when they go in, they're going in more like in their 20s and their 30s.
So, our final minute here, talk to us a little bit about the urban aspect of this. Is it mostly people getting arrested in cities or is it all across the country as well?
Well, yeah. So it's all across the countries. We definitely have higher rates of crime, proportionately speaking, in urban areas. So you would see major cities are going to have higher homicide rates, higher rates of crimes of violence. There are higher concentrations of population anyway, so you're definitely going to get more people. But even given their higher numbers of people, they tend to produce higher numbers of people being charged with crimes. Most of the people, though, who are serving their sentences, the prisons themselves tend to be in rural locations. So the actual place where they're going to be incarcerated will be in a community that tends to be rural. So here in New York, for example, most of the people who end up going to prison, it's going to be disproportionately people from New York City, but they'll serve their sentences in prisons that are upstate in lots of rural communities. So they're often far from home and far from their families, which makes visitation very difficult. And there are, plenty of people who do commit crimes in rural areas and suburban areas too. But in terms of the ratio, it's definitely going to be more people in highly populated areas. Those are also the areas that are more heavily policed.
Got it. Let's move on to our second question. The framers of the Constitution were clear eyed about the nature of government overreach as it relates to policing crime. Can you bring to light their far-sightedness almost 250 years ago and how the Supreme Court has deviated from their vision?
Yeah, so I think one of the things that's really interesting about the United States is that that I think a lot of people look at the politics in the United States and think, wow, it really tends to get harsh here. People really kind of clamor for long sentences, lots of policing, the idea that we would have a group that might be targeted for criminal policing and punishment, like a minority group. All of those ideas were things that the framers were well aware of. So when our Constitution was drafted, they were aware of abuses that took place in England under the Crown, where the king would target particular groups that the king didn't like. And would punish them very harshly. There was what was known as the Bloody Code in England because so many crimes were punished by death, and very severe punishments. So when the framers were drafting the Constitution in the United States, they wanted to put in protections that made sure that we didn't replicate that there were ways that you could make sure that people, kept their liberty and the government couldn't abuse its power. And so, in addition to what I think a lot of people in America learn about our checks and balances, dividing power among the branches, the framers also put in very specific checks related to criminal laws administration. So, there is the jury guarantee, which is a big one, which is if you face a crime that has a punishment of greater than 6 months incarceration in America, you have a right to a jury trial. And the framers thought that was super important because the government would not be able to take your liberty away for that, sentence of that length unless a jury of your peers agreed. So it's a way to get people outside the government checking to make sure the government could actually do that. In addition to that, there's lots of protections against the ability of the government to stop you, to seize you, to search you for things. The Fourth Amendment has strong protections against that because the idea is you should be able to go about your business, and the government would need probable cause to interfere with that and stop you. There's another amendment of the Constitution that deals with excessive fines and cruel and unusual punishment, so that you can't impose disproportionate sanctions against people for whatever it is that they've done. So there's many, and in addition to that, we have due process guarantees. So you get a certain amount of process. There's a presumption of innocence that's baked into that due process notion. And all of those things are designed to make sure that before the government could take your liberty away, it has to follow certain procedures. The jury should be interposed as a check. And there are substantive limits on the kind of punishment that could be given to you even after you've been convicted.
Got it. So the second part of this question is, and you write about it consistently throughout the book, is the Supreme Court has moved away from that vision, right?
Yeah, so it's the Constitution is only as good as the people who enforce it, and some of the terms that guarantee these rights, the court has just interpreted over time in a way that has diluted them. And in particular, when the government has come before the Supreme Court and has said, "Look, we need to be able to do." Whatever it is, as a matter of public safety. We need to be able to stop people on something less than probable cause, because we think public safety demands it. And we need to be able to search them or frisk them for weapons on less than probable cause. Um, the Supreme Court has agreed to that, even though if you look at the Constitution and you read the Fourth Amendment, you would ask yourself, how could they possibly do that? They cut some constitutional corners when the government makes these claims that something is needed for the administration and efficiency to function and for public safety to be protected. If those have been arguments that the Supreme Court has really fallen prey to kind of giving way to the what the Constitution would otherwise demand. And I think in current times we can see the current administration in America right now, the Trump administration is doing something similar where they'll say, look, due process, we can't give due process to all these people. It's too much, it's too burdensome. We would never be able to handle, the immigration problem with that. those are the kinds of arguments that historically we've seen in criminal law, where the government has said, look, we can't give them all these rights. You can't, we couldn't function if everybody had a jury trial, right? We got to be able to plea bargain. We've got to be able to make people trade those rights away. And when the government has made those claims, they have been largely successful, in part because I think the Supreme Court has not felt strong enough to resist them, either because the court is sympathetic to the arguments and kind of shares the public safety concerns, or has been very deferential to the government, or they might have a theory of interpretation of the Constitution that is just super pragmatic, and in their pragmatic view, the government was making the stronger pragmatic claim, and so they went along with it.
Rachel, let's move on to our third question. The first half of your book showcases pre-trial detention, plea bargaining, and disproportionate sentencing as growing by orders of magnitude over the past few decades. Which decisions by the Supreme Court has enabled these trends?
Yeah, so I start the book off with a case called United States versus Salerno. And that would be the case that would be the one responsible for pretrial detention exploding. And it basically, so for 200 years in America, you would not be able to go into court and say, I've arrested this person. And solely because I've arrested them, I'm going to say they're dangerous and they need to be incarcerated right now, before their trial, before they're proven guilty. Nobody thought that was okay, because we do have due process and a presumption of innocence. So you could say that the government could come in and say, I need to detain somebody because they're a flight risk. And if I don't detain them, they're going to leave the jurisdiction and we'll never get our trial. Or they might, they might threaten witnesses or destroy evidence. And again, we wouldn't get the trial, so we need to do something to preserve the trial. But those were the reasons that you were allowed to detain people in a criminal proceeding. If you wanted to make a claim that someone presented a danger, they were a danger to themselves or they were a danger to others, you'd have to use a civil commitment proceeding. You'd have to have a higher burden of proof, clear and convincing evidence about this idea of danger. That was the norm in America until the end of the 1960s, when President Nixon decided that he wanted to help craft a law in the District of Columbia that would allow people to be detained on the basis of dangerousness after arrest. And that law becomes a template for other state laws and for a federal law that also allowed detention on the basis of dangerousness, and in fact included some presumptions, like if you were charged with certain crimes, like a drug offense that had a statutory maximum of 10 years or greater, this federal law said you're presumed dangerous once you're dealing drugs under those statutes, and therefore you're presumed to be detained. That law makes its way to the Supreme Court, and the court decides the case in 1987 and says, yeah, that's fine. Despite the 200 years that we thought you couldn't do those things. And that really opens the floodgates to jurisdictions feeling completely comfortable detaining people pre-trial. Another case that is in that trilogy that you started mentioning is this idea of plea bargaining. So again, nobody thought that was legal. It happened. It happened kind of on the down low, where judges or prosecutors might have made deals, but they kind of did it in the shadows because they didn't think it was permissible. And again, this starting in the 1960s, there's so much pressure on court dockets. Crime is rising towards the end of the 1960s. You really just get a lot of pressure that says, well, why not just say plea bargaining is okay? Let's just bring it out in the open and say it's okay. And ultimately, the Supreme Court agrees with that, despite the fact that it's a constitutional right to a jury trial, as I've mentioned, and you shouldn't be able, as the government, to coerce somebody into giving away a constitutional right. There's this doctrine called unconstitutional conditions. We couldn't coerce you for giving away a First Amendment right or religious freedom. We wouldn't also be able to say, you lose this right to a jury trial because if you exercise it, we're going to burden you with an extra long sentence. The court should have said that's not okay, but because it was concerned about efficiency and administration, ultimately accepts it. And plea bargaining is another thing that really just opens the floodgates to mass incarceration, because you can't have mass case processing unless you can get cases mass processed through pleas as opposed to trials. So that would be the second case. And then the third area that you mentioned, which is disproportionate sentencing, that requires the court basically to render the Eighth Amendment of our Constitution, which bans cruel and unusual punishment. Basically, the court decides a case. It's in a concurring opinion, but it becomes the dominant test, which basically says, look, a state can impose a punishment as long as it fulfills any theory of punishment. And that can mean just incapacitation. It can be deterrence. And it doesn't matter if it's disproportionate as a retributive justice matter. So, what that ends up doing is condoning sentences like a life sentence for stealing a slice of pizza, which no one would think is proportionate. But if the state can claim, look, we need to incapacitate a repeat offender, this person has committed other thefts in the past, and this time we mean it, the Supreme Court said, okay. And so that too really fuels mass incarceration because it means you're getting these longer sentences with no effective cap. And, it also, the three of them relate to each other because if you detain people pre-trial, they're more likely to plead guilty because they'll take time served to get out of there. And if they are facing really long sentences with no check, again, they'll plea to try to get a better deal. So the three interact and really form the backbone of mass incarceration in America.
Let's move on to our fourth question. Allowing the government to stuff prisoners into facilities, new police methods like stop and frisk, and the continuing reality of racism and bias also play a role in the mass incarceration of Americans. Walk us through the Supreme Court's role in enabling the state with regard to these three factors.
Yeah, so these might not be as intuitively related to mass incarceration as the first three that we talked about, but they really are still a big part of it. So when it comes to prison conditions, there is a constitutional floor, right? You got to put people in humane conditions. If the state is going to take away your liberty, then the state needs to provide you with medical care because you're not free to go out and get it yourself. So there's certain minimal things that the state has to do once it decides to take you into custody. And it's responsible for maintaining this minimal level of prison conditions, including giving people sufficient space. Because if you don't have enough space, that has mental and physical consequences on people. It really has really dire health effects. So the Supreme Court, when it gets this first case that deals with overcrowding in America's prisons, ultimately decides that the jurisdiction that had it was basically putting two people in a space that was built for one. And so each person had a living space the size of your average door. That was their whole living space. And they were in those cells for all but 6 to 8 hours a week. So it wasn't like, they were milling about in common areas elsewhere in the prison. This was their space, other than the 6 to 8 hours that they were out for meals or for some other purpose. And experts testified to the court and said, this isn't enough. This is bad for mental health. There's going to be communicable diseases as a result of this. But the Supreme Court ultimately says it's okay. And I think, again, it was this kind of efficiency, government necessity argument because about 2/3 of all prisons in America at that point were giving space that small, double bunking, triple bunking, putting people in crowded conditions. And I think the court was reluctant to say that many facilities were unconstitutional. So it's effectively kind of like I think of it as a constitutional 2-for-1 or 3-for-1 sale because you're able to cram people into space that's really not meeting that constitutional minimum. The other examples that you mentioned, so stop and frisk is the case that I talk about as a matter of policing because that is another driver of mass incarceration is what you let the police do dictates who gets into the system in the first place. So if you're able to stop more people because the standard has been lessened, you're going to have more people funneled into that system. And in the case of Terry versus Ohio, the Supreme Court dilutes this Fourth Amendment requirement that says you would need probable cause that they're committing or about to commit a crime, and instead adopts what comes to be known as this like reasonable suspicion standard. So it's much less than probable cause, and it means that you can have policing, excuse me, that you can have stops on the basis of less than probable cause. So a lot of police departments in America go through massive stops as a result of that. In New York, at its peak, it was like 750,000 stops a year of people. And most of them end up going free. But when you're stopping that high quantity of people, you're going to get a lot of them that are going to be able to be arrested for some things, again, fueling mass incarceration. So the last thing is racial bias. And, that is a key driver of mass incarceration as well, because I think in America, if you were incarcerating people in proportion to their race, I think there would be more of a political blowback. But because it is so disproportionately targeted on communities of color, It's one of the things that allows it to survive politically. So the Supreme Court has made it very hard to be able to bring claims of racial discrimination, which means we have evidence that there's a lot of structural bias in policing, in prosecution, in plea bargaining, in the number of people incarcerated. And it's very hard to challenge that, because to be able to challenge it, you would have to be able to show that in your individual case, somebody evinced racial bias, like explicit racial bias. And so it makes it hard to show implicit bias, use statistical studies to show discrimination. That has been ruled off the table by the court. And again, big part of mass incarceration, just because politically speaking, that is what allows it to thrive, and not get as much pushback politically as it otherwise would.
Rachel, let's move on to our final question. You showcase throughout your book that it doesn't have to be this way. What are your thoughts on how the Supreme Court can return to its duty of protecting constitutional rights?
Yeah, so, I think that it's a kind of constitution in waiting for a group of justices to decide that they are going to adhere to the text. What I argue in the book, these cases are not consistent with the text of the Constitution, with its original meaning, which a lot of our justices adhere to that philosophy of judicial interpretation. They care about what the framers thought. And I put a lot of history into the book to show them that these cases are inconsistent with that. Um, and they're not great for public safety either. So even if you were a pure pragmatist, one of the things I point out in the book is that these things end up being bad for public safety. The government claimed it needed to do these things, but it really doesn't. So if you had justices that were persuaded by, any of those methodologies, these cases could be overturned. Now, you would also need justices who were willing to overturn precedent. We happen to be in America right now living in a time with a court that is very willing to do that. They have been overturning some major cases, in addition to Roe versus Wade, a case that established abortion rights, where the court overturned that, even though it was a 50-year-old precedent. Just recently, the court has signaled that it's also going to overturn a 90-year-old precedent, which established in America these things called independent agencies, which have agency heads that the president can only fire for cause. And the court has indicated, through an order, that it's going to overturn that as well. So that's a 90-year-old case that is really part responsible for a huge chunk of our government in America. So if you have a court that's willing to rethink precedent, even when it's old, even when it's been relied upon extensively, like those kinds of cases, that means these cases could also be up for grabs as well. And one of the things I think that's interesting about them is, even though they are cases that I argue could be overturned on originalist grounds, they're not, traditionally speaking, conservative cases, or kind of more Republican oriented cases. And so they're also kind of an interesting test case for the court in America, because, I think the court likes to claim it's principled, and, hey, it follows this originalist methodology. These cases are wrong. It's overruling them. It's interesting to see what happens if the court is faced with cases where the originalist methodology produces a more liberal result. And that's what these cases do. So, the court could do one of two things. It could overturn these and show that it is consistent, it is principled, it's following originalism wherever it leads. Or, if the court doesn't do that, then I think it's an interesting example of hypocrisy. It's an interesting way to highlight that the court actually isn't just following neutral principles. It is picking and choosing winners based on a political ideology. So, to be able to have the court, um, take a different position in these cases. I do think cases need to come before the court. I think litigants need to be able to push the court on these issues, which I hope they will. I hope they're start doing more of that. And my hope is that some of the justices, at least, would like the opportunity to say, yeah, no, hey, I'm a principled, consistent person. And sometimes that means the outcome is conservative, but sometimes it means, it's in favor of what, I tend to not think these things should be considered politically liberal or conservative. They're just pro liberty. But, politically speaking, in America, it tends to be, when you rule for something that benefits a criminal defendant, that tends to be associated with a liberal point of view. So if the court were to overturn some of these, I think it would help them show they are principled. Now, whether they actually did that remains to be seen, but that would be the optimistic and hopeful way that you do it. So maybe you appoint different kinds of justices, or you convince the current batch that these cases should be reconsidered.
So, our final minute here, Rachel, when you just brought up different kinds of justices, what do you mean by that?
Well, I think that professional diversity on the bench is really important. And to get people that have had experience representing criminal defendants, have had a career experience protecting constitutional liberties, civil rights work, because most of the Supreme Court justice appointees have been government lawyers. So, they have spent their career working for the government. And so I think that gives them a tendency to be deferential to the government, to assume the government acts in good faith. Maybe they don't question it as much. And they also might not know the kind of real world consequences to individuals when the government comes down hard on them. I think they're just blinded to the realities that a lot of people's lived experience show them, that these justices don't have that. And so I think a more professionally diverse group of people on the court would be very beneficial, because they can educate their peers. They can bring their own experience to bear on the decision making. And I think that would be one way that you could achieve that is getting people that have that kind of background.
Great, Rachel. Thank you so much for joining us on Books in Five. We've asked you 5 questions, and you've had 5 minutes to answer each one about your book. The title of the book is Justice Abandoned. I'll put a link to the book in the show notes. I definitely recommend everybody checking it out. Rachel, thank you so much for joining us today.
Oh, thank you so much for having me and for reading the book. I really appreciate it.
The host of Books in Five is Bhavan Sodhan. Books in Five is produced in collaboration with Podfather Creative in Vancouver, Canada.